All right, good morning, Chair Postman, members Garrett and Vollendroff, staff and guests. The lobbies are open and the recording has begun.
Thanks, Dustin. We will convene the Washington State Liquor and Cannabis Board meeting for Wednesday, June 21st, 2023. As Dustin mentioned, everything is being recorded. I'll ask everybody who's in the boardroom to silence your cell phones, take any side conversations out in the lobby. As a reminder, the speakers in this room are very sensitive and will pick up all sorts of noise. First item on our agenda is general rulemaking, and I have Daniel Jacobs, our policy and rules coordinator, presenting that.
Thank you, Chair Postman. Good morning. Thank you, Chair Postman, members Garrett and Vollendroff. This morning, I'm requesting to withdraw the CR 101 filed on January 25th, 2023, which initiated the rulemaking process regarding amending Washington Administrative Code 314-55083 and 314-55087 to allow cannabis licensees to use cloud storage for retaining records that are required to be kept on site. When this rulemaking project was initiated, the scope was broadened to examine whether rules should be created or amended to allow all licensees to use cloud storage for keeping required records on site. After months of thorough review, I'm asking to withdraw the CR 101 today because the agencies concluded that formal rulemaking on this topic is not necessary at this time, and rather informal guidance will suffice to accomplish these intended goals. Of the over 39,000 licensees of the Liquor Cannabis Board, there was a survey that was sent out to over 3,000 of them, approximately 100 of each license type, or where there are less than 100 licensees of a particular type statewide, the survey was sent to all licensees, and it was sent via email. The survey was open from April 14th to May 8th, and we got over 200 responses. On the cannabis side, we asked how licensees currently maintain their records, and of those who use some kind of electronic storage, the vast majority also keep hard copies on file. And now, while a slight majority of the alcohol licensees who responded don't currently use cloud storage, a majority of those who did respond would like some sort of clarifying statement about the permitted use of cloud storage. There's currently nothing in rule or statute that prohibits the use of cloud storage by licensees, and rather than go through formal rulemaking on the topic, the rules team concluded that providing general guidance along with some sort of general principles and advice will accomplish these goals while also ensuring that the use of cloud storage by licensees won't become a roadblock or a justification for failure to produce required records. If approved for withdrawal, the CR 101 will be withdrawn immediately, and notification will be provided on our website. Thank you, and I'm happy to answer any questions that you might have.
Thanks, Mr. Jacobs. So is it our intention then to issue the sort of clarifying statement that people have asked for? And what all would that say then?
Yes, it is. We're still in the process of wordsmithing that, but essentially we're going to be issuing some informal guidance later this summer. It's not going to be an interpretive statement or exactly a formal policy statement, just because we don't have any law or regulation currently on the books on cloud storage. But essentially the guidance is going to say that if you want to use cloud storage to keep required records, go for it. But there are risks that come with it, just like however you keep your records, not to sort of put the cart before the horse, but essentially we're going to be saying if you use cloud storage for keeping records and something happens to the server, that's going to be treated the same way as any other issue that, if officers come and need to look at these records and you can't produce them, whether it's because your storage locker, you lost the key, or your server's down, it's going to be treated the same way.
Okay, but showing somebody on the computer would suffice.
Yes, for showing the records, but a lot of times, if LCB officers need to be able to take the records back, that's sort of where we're getting the details on, whether you have to put it on a thumb drive or print out copies of it. That's where we're still sorting out the finer details of it.
Okay. All right. Good. Any other questions on this?
I have a question.
No.
What you said. 8A358.
I know.
We do not respect,
You don't-
the law.
No,
Because
I
we
know.
be mislead, we are the pioneer.
Sammy, you're not
We
allowed
be left. I know,
to
but I
talk
just wanna
during the
understand.
meeting.
Go ahead. No problem.
Just stop. We'll try to do better to explain things. So
Okay.
any other questions? No? Okay, then what we're gonna do is look for a motion to withdraw the CR 101 for cloud storage. And what this was a request from cannabis businesses initially to be able to store their LCB required records on the cloud in a network rather than in physical, and we don't need that in place. And there's nothing in current law that or rule that prohibits it, as we've discovered. So, is there a motion to withdraw the CR 101?
I move that we withdraw the CR 101 for cloud storage.
And a second.
And I second that.
Okay, then that is withdrawn. Thanks, Mr. Jacobs.
Thank you.
Now, the next rules petition review and consideration is the request to amend WAC 314-35075, which would add vapor in front of product to clarify that it refers to a vapor product. Is that also yours, Mr. Jacobs?
It is. Lucky me.
Go ahead.
Good morning still. This morning I'm presenting the petition that, as mentioned. The agency received a petition for rulemaking from Chris Gerard on April 26th, and he requested that the word vapor be added in front of a particular instance of the word product in Washington Administrative Code 314-35075. Mr. Gerard had previously submitted a petition for rulemaking, but that had been denied because he was technically asking to amend a statute, which we can't do. The particular section of WAC 314-35075 says as follows, that it's a violation to, quote, sell, give, or permit to sell or give a product that contains any amount of any cannabinoid, synthetic cannabinoid, cathinone, or methcathinone, unless otherwise provided by law. And it's that instance of the word product that Mr. Gerard has petitioned that we insert the word vapor in front of to clarify that it's talking about a vapor product. The problem is that there is a companion statute, which is RCW 70.345.030 subsection 4, which also uses the term product and contains an identical prohibition, almost word for word, that no person can sell or give any product containing any of those other things that I'm not going to repeat again. The statute was drafted by the legislature, and as mentioned, we have no authority to change the wording in that statute. So by its own wording, the term vapor product is defined in statute. However, just the word product isn't. If we were to change our rule to limit this to only vapor products, we might be crossing the line and narrowing the scope of the regulation beyond that which is limited in statute. And that could be problematic for legal and enforcement reasons where we're interpreting our rule more narrowly than the statute's intended. As such, we're not clear that we have the authority to even do this. And where we're not clear that we have the authority to do this, we err on the side of tending to recommend denying the petition. And so therefore, this morning, I'm recommending that the board deny Mr. Gerard's petition for rulemaking because his requested change may limit the scope of the regulation beyond that which is intended by its companion statute. I've attached my analysis as well as the regulations at issue, but I'm also happy to answer any questions.
I have one, what, if you can, tell us what is the ill that Mr. Gerard is trying to cure here? What was the original concern?
So this comes, and this is per his emails. Essentially, what he says is that this regulation is being used to take non-vapor products that are being sold in vape shops, vapor and tobacco licensees. Examples he gives are cannabis health and beauty aids, commonly known as Chaba, but there are other products that are sold there. And his goal is to say, listen, this is a vapor regulation. This should only really be talking about vapor products. And while from a broad view, that's correct, The problem is that the statute itself, that particular section, doesn't appear to be limited to vapor products. The legislature, at least how we're interpreting it, if they wanted to limit it to vapor products, the prohibition would say vapor products containing cannabinoid, cathinones, and the others, but it doesn't. It just says product. And so Mr. Gerard's concern that this seems impermissibly broad is actually arguably exactly what was intended, that it is meant to be broader than just vapor products.
Right. Okay.
And so I guess the next step would be that Mr. Gerard's sort of request for change, really, this is something the legislature would have to do, that the legislature would need to amend the companion statute. And if they were to do that, then we would most likely need to amend our companion rule.
Right. Okay. Jim?
Thank you. Thank you, Daniel, that you actually just clarified what my question was going to be. So without weighing in whether this is a good idea or a bad idea, just making sure that Mr. Gerard knows where he needs to go should he decide he wants to pursue this. So thank you for that clarification.
Certainly.
All right. Then with that, is there a motion? Motion would be to deny the request to add vapor in front of product in the WAC 314-35-075.
Yeah, this is Jim, and I move that we deny the request to add vapor in front of product to clarify that it refers to a vapor product.
A second?
This is Ali, I second.
Great, then that is denied. Thank you again, Mr. Jacobs.
Thank you.
Okay, we'll move to cannabis-related rulemaking, and Dr. Kathy Hoffman, our research manager, will present the next rules petition. Good morning.
Good morning. Thank you, Chair Postman. Good morning. I got Board Member Garrett and Volendroff as well. This morning, I'm going to present on a rule petition that the agency received on April 26th from Mike Asai of Black Excellence in Cannabis, asking that the board amend the social equity application scoring rubric number 8. And this is a quote, because there's no clear transparency regarding qualifications for formal medical cannabis dispensary owners. And this particular rule is contained in WAC 314-55-570. And so the issue before you today is to consider whether the board should initiate rulemaking to make that change. Mr. Asai did provide some specific rule language. So just to compare, the current scoring rubric language provides, and I'll just read it verbatim. Did you own or operate a medical cannabis dispensary or collective garden licensed as a business prior to July 1, 2016? So under the current scoring rubric, that's 10 points. Or did you own and operate a medical cannabis dispensary or collective garden licensed as a business in a DIA, so disproportionately impacted area, and that would have been 30 points. So Mr. Asai would like to see the language changed to say, did you own or was a governing member of a corporation known as a medical cannabis dispensary, known as a collective garden in a brick and mortar prior to July 1st, 2016. So just going through the rule petition response, I did provide a rule background for you. I think we're all familiar with that history, but just to abbreviate it, we did file a CR 101 in November of 2011 on this, or I'm sorry, not 2011, 2022, my apologies. Moved forward with rulemaking, filed a CR 102, so that's a rule proposal in April of 2022. In August 3, we provided amended proposal or a supplemental proposal. We withdrew and refiled. And then on October 13th, the board adopted final rules on this that became effective November 12th. Sorry, that recitation was a little bumpy there. So the rules haven't been in place for a year yet. And also we have applications that are being scored against that rubric right now, just to give you some additional background. So with respect to impacts on divisions, and again, going through the recommendation document, we don't see that there would be any impacts on the divisions with respect to this rule change or the request.
I wish. We've been Pioneer for the longest.
Please
Enough
don't
is enough.
interrupt. Please, you're gonna have to leave.
Well, I just have a video. I have to
You-
release it to
you
the
can't-
internet. Okay, that's
You
fine.
can't
That's
interrupt.
fine.
You can't.
That's fine. We don't have to go.
I'm gonna.
That's
ask
fine.
you
That's
to
okay.
leave the
That's,
room.
that's
Okay?
fine. You want me to sit outside until my
I just
turn
want you
to come to
stop
tell me
talking.
what to speak, Mr. David?
I want you to stop.
Okay,
talking.
let's go respect each other, not with religions, with respect as a human being, as United
You
States.
need to stop talking. Go ahead,
Please.
Dr. Hoffman.
Thank you, Chair Postman. So moving on to our recommendation for this particular petition. On May 1st of this year, Governor Inslee signed Engross Second Substitute Bill 5080 concerning various provisions of the social equity and cannabis program into law. And our existing rules, the ones that we've been referring to here, will need to be amended or repealed, and new rules will need to be created to implement that legislation. So agency staff are currently in the process of reviewing that bill and strategically planning the significant work that will be related to it, including rule development that the bill will require. At the same time, we're also observing the social equity application process as currently described in rule. Agency staff will rely on those observations, including whether the social equity scoring rubric should be amended to inform future rule development once the current round of social equity application review is complete. This can then be combined with the rulemaking requirements of the bill to provide a more robust, comprehensive, and complete collection of rule revisions. So we really will be looking at rules in upcoming rulemaking that we anticipate commencing probably towards the end of July, early August. So for these reasons, we recommend that the board deny the petition at this time to amend element 8 of the current social equity scoring rubric.
And
So-
go ahead, Ollie.
No, I was just gonna say, so Kathy, what we're saying here, we're denying this rule petition, but we will, when we start doing new rulemaking going forward, all of these things will be taken into consideration.
That's correct. We will
Okay.
have all of that rule section will be open. So that's 314.55, 570, including the scoring rubric, will be part of that rulemaking.
I couldn't understand. Can
Okay.
she explain
All right.
very early
Thank
there
you.
because she missed me out before that. And her boyfriend, two boyfriends.
You don't have a
like,
chance to talk,
just
so
wanna
you need to
understand what she's
stop.
saying.
You need to
I
stop.
want to understand what she's saying. I couldn't understand it. Can I understand? Treat me as a human being. I am American too. I'm a black person. I've been messed up. Respect me as a human being. I want to understand what she said. She told me don't call me anymore.
Sammy,
She
this
missed
is-
me out before that. You guys know that. We the pioneers since day one. We've been forced out. I need to know what she said. I came here. I drove from Seattle. Can you make me understand and treat me as a human being? Not like the United Nations treat us like Africa, like now we are bullshit. Enough is enough. This is the 21st century. I need to understand. No disrespect. If you want to harass me, not get my application, not to get the equal opportunity, that's fine.
It is
I'm respecting
disrespect.
you as a human
No,
being.
you're
Respect me
not.
as a human
You're
being, as a black person.
disrespecting,
I started first.
you're disrespecting me.
I'm not disrespect. I want to understand for my, she disrespected me publicly.
And disrespecting the members.
I'm not. I am not. I need to
Because only
understand.
you-
No, please don't make people hate me because I'm not anti anybody. Please, let's go. Let's go move on. Can we move on?
Rules, everybody.
Yeah, let's go
else.
move on. Let's go move on. I don't want to hear anything. Let's go move on.
Make
That's
it
it.
very clear.
Let's go
You
move
gotta
on.
make
That's it.
Very clear.
I am
You
not gonna
interrupt-
speak
if
other
you
than there.
interrupt-
Let's go move on. That's fine.
If you interrupt
Thank you
this
so much.
meeting One more.
One,
time,
educate me, please. I want to speak there. That's it.
If you interrupt this meeting one more time, I am going to ask you to leave the meeting room. You'll have your chance to speak soon. Do not interrupt one more time, or you're going to have to leave the room. You have to respect this board meeting. I just wanted to add to what Member Gar said. Certainly my intention as one board member to have robust discussions around the entire rubric. I think the one we came up with was great. I think we're learning. We don't know, as you point out, we have the current system in process now. We don't know the timing exactly when that's completed versus when rulemaking will start. We're still trying to figure that out. But we're learning every day. And so I think we'll do that. And I think that accepting the petition wouldn't have added anything to our ability here. We're going to look at was that number 8? Is that what that one was? But we're going to look at all of them.
That is
I
correct.
think we should take a look at all of them and make sure. So those are my thoughts. Any other questions or comments on this one? If not, then is there a motion to deny the petition that would have amended the social equity rubric?
This is Ali. I move that we deny the petition.
And a second?
Thank you.
This is Jim. I second that.
And then that is approved. Okay, our next action item is board review of the CR 101 for engrossed second substitute Senate Bill 5367. This is the THC bill. And Cassidy West, our cannabis side analyst, will present that. Good morning.
Good morning, Chair Postman and board members Garrett and Vollendroff. I'm here this morning presenting the CR 101 on the implementation of engrossed second substitute Senate Bill 5367 and requesting the board's approval of this filing. First, I'd like to provide some background on the legislation. The legal status of THC has been uncertain since the passage of the federal 2018 Farm Bill and the state's equivalent legislation, engrossed second substitute Senate Bill 5276 was enacted in 2019. Although the legislation was intended to create a legal regulatory framework for hemp, it inadvertently created a market for intoxicating products containing synthetic THC derived from hemp, like Delta 8. In 2021, the LCB initiated legislation as House Bill 1668 and its companion Senate Bill 5047, entitled Expanding Regulatory Authority over Cannabinoids that May Be Impairing and Providing for Enhanced Product Safety and Consumer Information Disclosure about Marijuana Products. Among other things, the proposed legislation amended the definition of THC, prohibited certain cannabinoid products, and expanded LCB's regulatory authority over products that may be impairing. Although the legislation was not successful, the agency introduced House Bill 1612 and Senate Bill 5367 in 2023, which was ultimately enacted in April as engrossed second substitute Senate Bill 5367, Chapter 365, Laws of 2023, concerning the regulation of products containing THC. This act will be effective on July 23rd, 2023. If approved for filing today, there would be a public comment period until August 7th, 2023, and we would tentatively have rules in the CR 102 filed on or after October 25th. A public hearing at the beginning of December, and assuming things proceed as planned, we would have this CR 101 to be filed, in January 2024, with the rules becoming effective on February 3rd, 2024. So based on this, I ask for your approval to file the CR 101 today. Thank you, and I'm happy to answer any questions.
I have sort of a basic one. We don't really have a choice, do we? I mean, when
No, not
piece of
really.
legislation's passed like this, we have to do rules to implement it, right?
That's correct,
Right.
yes.
So we're just, we're starting the process that we know we have to follow and go through this. And yeah, I think this is not going to be easy, but you probably already know that.
I do.
I think there's a lot packed in here. So anyhow, okay. Look forward to that. All right. Is there a motion to approve the CR 101 to implement the new THC bill?
This is Jim. I move that we approve the CR 101 for engrossed Senate Bill, Substitute Bill 5367 concerning regulation of products containing THC.
Great. In a second.
This is Ali. I second.
Great. Then that's approved.
Thank
Thanks,
you.
Ms. West. Appreciate that. That takes us to general public comment period of our meeting. Everyone has up to 4 minutes to speak. You don't have to speak for the full 4, but you can't speak any longer than 4. Hope that people can limit comments to LCB business and of course refrain from personal attacks or going off topic. Ask you to be respectful to the speakers and everyone else who is present, both virtually and in person. Do not disrupt the meeting or people making public comment. If we have disruptions, I'll pause public comment until the disruption stops or we clear the room. And again, everything we do is recorded. It'll be available online later today. Another reminder that in the room here, very sensitive microphones. So when people are testifying, let's give them our full attention. I'm going to start with people who were signed up in the room, and that's you, Mr. Saad.
Sami Saad, in behalf of the Sudanese and Somalian and the Ethiopian
If you
community.
can do it from the podium so we get the microphone.
I wish the video to be told me to be clearly, so,
It will.
yeah,
It will.
because I have
Okay,
this
you
one.
have 4 minutes starting now.
Yeah, this one is reflect what we're going through. And this is all over the city. Black people being forced out of Washington, Kennedy, in Seattle. I've been having 2 shops being forced out. And a lot of people, they determine we're not buying from those shops anymore. So you guys damaging the legislator. Second, a lot of people from our people, they're not voting Democrat anymore. They're voting Republican. And even if the Republican, they be clear and they help them. Mr. David, we have something now. This is about the social equity program. And for those pioneers, they're being forced out. You voted against. Is that correct? The social, the one that for the cannabis, for those pioneers, you guys make this legislate or those HB 2870, and you guys lied to us and disrespected us. You guys say this is for the pioneer, the Black pioneer being left out. I am the first shop in Seattle ever, and with database from the state, from the city, I've been left out. Uncle Ike's, have a heart. Go to their background, all of them. I need everybody to go without me saying, sue their background, other shop, another shop, all white. I'm not against white, but it's not fair. You have people, they came from you guys, they came in Highland Community College. I was trying to ask questions, we have video, they don't want to answer for me, they run away from me. And one of them, she's sitting in a room. That's very disrespectful for us. And there's a video there. So, and another thing too, I've no disrespect for you, Mr. This is about us. We lost money and we lost shops. I'm a general contractor. That's why you see me like this, and that's why you see my booth. That's how I feed my family. When I have my shop is open, you can go to the data. I was working for Westwood Fishing Company. That's the money I feed my family. And I was working as a longshore in Alaska. I don't feed my family from cannabis, but I was helping the community. You guys damaging the community, damaging my community. I'm Sudanese American. I'm Muslim. I've been calling my name. Mr. Abdullah, you need to withdraw your application. My name is Sami Abdullah Saad. What I know in the United States, they call you by your first name and last name. It's very sad for me when we be disrespected and not being acknowledged and we being that way. And a lot of time I came here for 2-3 years, living public comment. You never, Mr. David, put that comment, but everybody else, they can. I don't have nobody to represent me or other than us, those pioneers, and you guys know us. Being left out, Libby, the first lady, a Black lady, being her high school is being suspended, and she never even opened a shop. She just have a hope. You guys take her hope away. Me too. You guys damaging me, damaging my community. I have kids that go to school. We have hope to open a school for them, and we pay. I'm not promoting for this one. If I open my shop, the first one, and I was working in Alaska, the same year, the next year, the year after, what that mean? I'm not better than anyone. I'm Muslim. I don't want that money for my family. I own enough. I'm originally from Sudan. We have enough to mislead those Black people. The same misleading for the war in Sudan. It's not between 2 generals. It's between 1. And the rabbit force is fighting everyone. That's what you guys fighting us. Ailey Garrett, not for us. Ailey Garrett called me. She said she want to help me publicly in illusion.
Tammy, you have 30 seconds.
Do not call me any more ever. If I have update, I'll call you. I have 26 minutes. Second, please let me speak, because this is, and I don't want a harassment for my application. I need investigation by the FBI, by the CIA, anybody who is investigated by the court system on my application there. I heard something from the background, and I have a thing I can hear. I buy it from the internet. That's the thing they cannot understand. That's how I record stuff. But everything I'll release it online one day.
Thank you. Appreciate that.
We need to be
Your
acknowledged.
comments. We'll move to virtual speakers, and James Shelton is the first I have signed up.
Good morning, Chair. That's a typographical error on my part. It's Kevin Shelton, but he is not online with us today.
Okay. Then we'll move to Christopher King. And you should be able to speak now, Christopher.
Okay, I believe I'm on now. Great.
Can hear
Just-
you. Can't
can
see
you hear
you. I can hear you, but we don't see you yet.
Oh, that's odd. Hang on. No camera?
There you are. Yep. Yeah,
Okay.
loud and clear now. Go ahead.
Great, great, great. I want to touch on some disrespectful things first. Sammy got out of line just now, but let's back that up a bit, just as I did with Margaret Belcher last week when I told you the story about that Black woman I represented in Columbus when they wouldn't give her Title 20 monies and the county messed with her endlessly and she could no longer continue to be a daycare provider. You know, we went through summary judgment. We beat that on the racial claims in 1981 and 1983, did that. And in any event, empirically, this board and the LCB has been unfair to Sammy Saad. On information and belief, he may be the first operation of his kind. And we asked more than a year ago for all the records, his records, application records with LCB. We know that a federal judge lied and said that he didn't apply for a retail license. That's false. I have part of his file. And we asked you guys for that file more than a year ago, and I don't think we've still gotten it. We still received it, okay? That's disrespectful. Ab initio, a priori. So when you get to him being upset with you now, I kind of feel the brother, all right? Just saying. So now, granted, you guys have just given out a flurry of document responses to me as you do, like you could just send them like months later. So I got to weed through them, but weed through them. But the thing is, I don't think that the responses are in there. And so it's been quite a while, guys. So yeah, he has a right to be upset. Now, as far as transparency goes, which was the subject of that which was presented by Mike Asai, he says a lot of good things, but there's nothing that we haven't said as the original and pure founders of Black Excellence in Cannabis, okay, Aaron Barfield. We've been saying that all along, that there is no transparency and there are problems, okay? But now we turn now to the problem in Denver. Okay, well, you guys are hiring this guy, Bill Lucala, William N. Lucala. I found an op-ed piece by Sarah Woodson, Black woman in Westward. This story ran. And she's saying that, what is taking place is an exploitation of the arrest criteria by millionaires who are currently operating and heavily resourced. They're saying, and the headline says that Colorado's social equity marijuana rules serve big business. That's what I've been telling you all along. I've never wavered from that. And I don't need to be obsequious to you when I step to the microphone like other certain Black people are saying, oh, I know the board's moving in the right direction and all that touchy-feely crap. I'm not down with that. I'm down with the facts. All right. And this guy, there's questions. What made you? Okay, look, the weed delivery thing that they had exclusive to social equity companies, that was a fail because almost nobody uses it. All right. And that's something you guys thought about here. I call it the driving Miss Daisy. Driving Miss Daisy solution. Y'all Black folks can shuttle the weed around to the white man. Yeah, sure. And meanwhile, you look at the pioneers like Sammy, Kevin, those guys were doing good things in the communities. They never had any problems. Unlike your Khalifas, you managed to find a way to get Khalifa more licenses when your own lawyers said the stuff they were doing would turn your hair white. When they lied to the U.S. trustee, it's a fact.
You have 30 seconds.
Pulled the records up on Pacer. So what is it about this guy? Okay, and not to mention they're not corrupt like the people over there in Purple Haze and in Everett, paying under the table and all that stuff, not paying taxes. So what is it, guys, that compelled you to hire Bill Lucala? I read the stories where Ollie Garrett said we welcome him and we're excited. What is it about him that excites you, and why is he qualified for this position? Could someone answer that, please? The three of you are right there.
All right, and that's your time, Christopher.
Okay. Great. And that's the last
Fuck you.
person.
Yeah, you motherfuckers ain't got shit to say. It's
Please
always that way with you.
Please mute him.
Well, mute me. You cut me time.
Thank you. And with that, we're adjourned.
Finish or?
Yeah.
We're done.